Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Here are the headlines. Procreation necessarily means union between man and woman, argued Solicitor General Tushar Mehta on day 6 of the same-sex marriage legalization case hearing. Practitioners of Ayurveda not entitled to same pay as doctors with MBBS degrees, holds Supreme Court. Supreme Court modifies its previous order on absolute ban on construction in eco-sensitive zones. Calcutta High Court transfer probe in Ram Navami Violence to NIA. Karnataka High Court evolves triple test while hearing plea of couple seeking child through surrogacy. Now let's take a detailed look on the headlines. On day 6 of the same-sex marriage legalization case hearing at the Supreme Court, Solicitor General Tushar Mehta, arguing on behalf of the government, told the Supreme Court that procreation necessarily means union between man and woman. SG Mehta made reference to provisions prescribing conditions of solemnization of marriage and highlighted on provisions concerning persons of unfit mind and procreation. On this, CJI D.Y. Chandrachud said that in case of heterosexual couples, the fact that one of them cannot procreate does not invalidate the marriage, and so procreation point may not be applicable in the present case. Yesterday, the top court was told that it does not possess the power to rewrite or alter the fundamental architecture of law, as conceived at the time of framing, and the impact of socio-legal recognition of same-sex relationships as marriage on the society as a whole has to be kept in mind before a decision in the matter is made. The Supreme Court, while setting aside a Gujarat High Court order, held that practitioners of alternative medicine such as Ayurveda are not entitled to equal pay as allopathic practitioners holding MBBS degrees. The court reasoned that such practitioners are not involved in performing emergency duties and complicated surgeries, and further said that Ayurveda practitioners cannot provide with the trauma care or emergency treatment as done by allopathy doctors, and noted that even post-mortems are carried out by allopathy and not Ayurveda doctors. The Supreme Court modified its order passed in June 2022, mandating national parks and wildlife sanctuaries to have eco-sensitive zones of minimum 1 kilometer to be measured from the demarcated boundary of such protected forest to act as a shock absorber, while also lifting the ban on construction activities within the ESZs. The modification was made by a bench led by Justice B.R. Gavai and also comprising Justices Vikram Nath and Sanjay Karol, who noted that its 2022 order on uniform ESZs was not workable and prohibition of all developmental activities within such zones is impossible to be implemented. The court also said that the requirement of declaring ESZs is not to hamper day-to-day activities of the citizens, but is meant to protect the precious forests and protected areas from any negative impact, and to refine the environment around the protected areas. It was, however, clarified that mining in the national park and wildlife sanctuaries within an area of 1 kilometer from the boundary of such protected forest shall not be permissible. A division bench of the Calcutta High Court, comprising the acting Chief Justice T.S. Sivagnanam and Justice Hiranmay Bhattacharya, ordered the West Bengal police to hand over all relevant material of the Ram Navami Violence case to the National Investigation Agency. The bench made the order on a PIL filed by BJP leader Suvendu Adhikari, who sought the probe by a central agency in the violence that broke out in several parts of the state amid Ram Navami celebrations this year. The acting CJ remarked that we believe a central agency can probe this aspect better. The High Court of Karnataka ordered that a couple seeking permission to obtain a child through surrogacy undergo a triple test. The 3 tests, as prescribed by the court, were genetic, physical, and emotional tests, which according to the High Court, the petitioner husband has to pass to become eligible to become a father through surrogacy. The observation came from the court on a plea filed by a couple seeking permission to obtain a child through surrogacy after their only biological child died in 2022, and they were unable to opt for surrogacy as the man was 57 years old, which is above the age of 55 years old, as has been prescribed under the Surrogacy Regulation Act of 2021 to have a child through surrogacy. The court also said that the provisions in the Act which states that surrogate mother should be genetically related to the couple who wants to have a child through surrogacy defeats both altruism and logic. However, the plea for quashing several sections of the Surrogacy Regulation Act was not considered by the High Court, as a similar matter is sub judice in the Supreme Court. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.